Hello, my name is At Melrose, and this is one of short informational videos that I've decided to put together on behalf of the lawyers here and staff at Melrose, Seago Lay. You can reach us at mountainverdict.com or 1-800-222-2430. One of the things we always have to consider on a contingency case, which is where we do a case based on the attorney's fee being a percentage of the recovery, is whether or not it's cost effective to represent the person based upon the circumstances of their case. And the things we have to consider are what is the overall likelihood of success that we're going to be able to win the case, and also what is the approximate amount of the recovery that we could make on behalf of the client. If the case is too small in terms of injuries and dollars and cents damages, often the person is better off representing themselves and negotiating a settlement directly with the insurance company, or sometimes we're forced to turn down a case because of factors where we cannot prove that the other party was 100% at fault in causing the injury. Sometimes this happens if our client that's seeking representation might have been speeding, even though the other driver ran a red light. The law of North Carolina is very harsh about that. It's the law of contributory negligence, and sometimes that can prevent any recovery despite the injuries. So we have to weigh out the severity of the injuries and the likelihood of success on what we call the liability, or whose fault it was. When we weigh all those things together, what I've found over the years, and having done this a long time, is unless I feel like I can be of substantial benefit to the client, where even after paying the attorney's fees, they should be significantly better off than if they negotiate a settlement with the insurance company on their own. And for that reason, frequently we tell folks that you would be better off representing yourself, because I don't think that after you pay attorney's fees and the cost of litigation that you'll be substantially better off. And so for that reason, sometimes people are disappointed, but I think most people appreciate the fact that we give them the truth about whether it's what we call cost effective to represent them in a claim for injuries. If we do take your case, we put our time and our resources and our energy behind it. We spend the money on the costs, the filing fees, and everything else, expert witnesses, depositions, everything else that needs to be done to successfully prosecute the case. And if we lose, the client doesn't pay us a penny. They don't pay us for any of our time, nor do they pay us for any of those costs that we've spent on filing fees or experts or transcripts or exhibits or anything like that. So in other words, if we take a case, I feel like we can be a substantial benefit to the client. We can comfortably invest our money and our time in an effort to make sure that the client makes a full recovery, and even after paying the attorney's fees, they are going to be significantly better off. And so for that reason, we examine the cases carefully up front. We don't take every case, because I think law firms that take every case are doing a disservice to people, because if the person could